Hi, I'm Raymond Chandler with the Polaris Law Group out of St. Charles, Missouri. We do estate planning, elder law, and estate settlements. And I wanted to talk to you a little bit today about one of the things we see a lot of times is one of the big mistakes we see in estate planning, and that's joint ownership with a non-spouse. And what we see a lot of times is when families are trying to do kind of DIY at-home estate planning without the advice of an attorney, a lot of times they'll think of, well, just in case I become disabled or in case I pass away, I want my daughter, my son, my nephew to be a joint owner of one of my assets. So sometimes it's a home, sometimes it's a bank account, a lot of times it's a bank account, or any type of asset that you may have, that you make that person a joint owner. And it seems to accomplish the task that you want. It seems to be able to take care of what happens if you're disabled. Well, that joint owner can go in and take care of your bank account for you. What happens if you pass away? Well, that joint owner becomes the owner of that bank account. The problem we see, though, is that doesn't cover one of the major goals of individuals during stage one of their estate while you're alive and well. While everything's going okay, a lot of people have the goal during that time to be in control of their own assets. You don't want to lose control of your property, your stuff, while you're alive and well and can manage it yourself. But adding that joint owner takes that control away in two major ways. One way is that it's going to give control to that joint owner of the asset that they are named under. So let's say it's a bank account. That actually gives that joint owner, whether it's a daughter, a son, a niece, nephew, a friend, a sibling, anything like that, it gives them control over that account. So they could go in and empty that account without any instructions from you, without it having to be in your best interest for any reason, because they have control over that account. Or they have control over their home and they could actually force you to sell it. All sorts of things like that, where you actually lose control by adding that joint owner to your account. And then the second problem that we see a lot of times is that now that that joint owner's there, all of that joint owner's liabilities are there as well. So if you add your daughter to your account and then she gets sued, gets in a school bus accident and gets sued for millions of dollars, anything like that, then now her liabilities could attach to your asset because she owns that bank account with you. And so if she owns that bank account with you and she gets sued and everything she owns is liable for that lawsuit or that bankruptcy or that divorce or any sort of creditor predator situation, now your asset is liable and could be held up and controlled by that lawsuit, by that issue. And so again, another situation where you're losing control of your assets while you're alive. So what is a better solution for that? A better solution for that is naming people to be in control of your assets at the proper time without being an owner of that asset. So what that looks like is either through trust or powers of attorney, using a document that states if I can't make decisions or if I need help, or if I want to direct somebody to do this for me, that these would be the people in charge and in control for me under my instructions. But they're not an owner of that account. They're simply an agent of mine that's working for me, almost kind of like an employee, but a little different. In that, so now in the bank account, I either have a power of attorney or a trust that says, if I can't manage my own affairs right now, then my daughter would be in control. Okay. And if my daughter's in control, she should, under the documents, now she has to act in my best interest, not her best interest, my best interest. And so it takes that one issue away, that they can't control it just for themselves. They have to control it for your best interest or under whatever instructions you put into your trust. Secondarily, let's say I name my daughter as my agent and she is power of attorney or trustee over my bank account, because I can't manage my own affairs at that time anymore. But then she gets in a lawsuit and she gets sued or she gets a divorce or something happens in her life. Well, again, since she's my agent, she's not my co-owner or my joint owner on that account. She's simply my agent working my assets for me. Those assets are not now subject to her liabilities because those are not hers. She does not own them in any way. She is simply an agent on my behalf, either a power of attorney or a trustee again. So by setting up a proper estate plan, by making sure that we're focused on how do we protect your assets when you pass away, but when you're disabled, and more importantly, not losing control while you're alive and well, by setting up a proper estate plan to do that, you're able to maintain that control during your first stage of life, alive and well is what we call it. You're able to maintain control, leave your instructions, not be subject to other people's liabilities, and really be able to control your property the way you see fit until and even beyond a point of disability or death, because you're leaving instructions behind to tell people how to handle your assets. So again, we tend to see a lot of joint ownerships for quote unquote estate planning, but it's not a good way to set up your account because it does lead to some disadvantages. And so we'd much rather see a proper power of attorney, trustee, trust, wills, things like that to show who you want to be in charge and help you, but not who to be in control and own your stuff. So again, I'm Raymond Chandler with the Polaris Law Group, estate planning law firm out of St. Charles, Missouri. If you need anything, have any questions, please give us a call and we'll help you out.